So we have a massive new development in the legal battle over the ATF's frame and receiver rule that was put in place by the Biden administration. And this one is going to sound a little bit confusing at first. You may remember that the Supreme Court previously ruled 7-2 in a case called Bondi versus Vanderstock, and that was in favor of the ATF's frames and receivers rule that was put in place by the Biden administration. And the Supreme Court found facially that it was not inconsistent with the GCA. So in other words, the Supreme Court concluded that Congress's definition of a firearm was broad enough to allow the ATF to regulate at least some unfinished frames, receivers, and weapons parts kits. Now that looked like a major victory for the ATF, but there was something also extremely important that the Supreme Court did not decide in that case. They did not decide whether the rule was actually a violation of the Second Amendment and the Constitution itself. And now that question has gone back down to the District Court Judge, Judge Reed O'Connor. He ruled in the Northern District of Texas. And again today, he issued a new finding that major portions of that ATF rule are unconstitutional under the Second Amendment and also void for vagueness under the Fifth Amendment. This is a major victory, once again striking down a portion of the Biden-era gun control efforts that they put in place. So let's talk about what happened in this ruling, who is actually protected under this ruling, and what may happen now going forward with this case. Now, before we jump into what happened in this ruling, if you want to continue to get these videos going forward, make sure to subscribe to the channel and also turn on all notifications so you get updates as I release them. Now, for a recap of what happened in this case originally, essentially the first time that this Vanderstock case reached the Supreme Court, the central issue was a statutory question. The plaintiffs argued that the ATF had exceeded the authority Congress gave it under the Gun Control Act by expanding upon the definitions of a firearm, frame, and receiver to include certain unfinished products like 80%ers and kits. Now, on review, the Supreme Court rejected that facial challenge. The Supreme Court concluded that at least some weapons parts kits can qualify as firearms, and at least some partially complete frames or receivers can also fall within that definition. But here's the caveat that has led to this new ruling by the lower court. The Supreme Court did not decide whether the Biden ATF rule violated the Second Amendment or other constitutional principles. And after the case returned back down to the district court, Defense Distributed and the Second Amendment Foundation, or SAF, continued pursuing those constitutional claims against this rule. And now Judge O'Connor has issued a new ruling today in favor of granting them a motion for summary judgment on the merits of this and striking down this rule based on various violations of the Constitution. The first major victory involved the Fifth Amendment. The ATF's rule says partially complete frames or receivers can become regulated firearms when they may be readily completed or when they are sufficiently developed to be clearly identifiable as unfinished firearms components. The problem with this, according to Judge O'Connor in this ruling, is where exactly is that line? The ATF lists factors like time, ease, expertise, tools, availability to parts, expense, scope, and feasibility, but Judge O'Connor concluded that this still does not give the ordinary law-abiding American a sufficient, clear legal standard for determining when an unfinished piece of material suddenly becomes a federally regulated item or a firearm. He specifically criticized the rule for leaving the meaning of readily to a list of non-exclusive factors that ultimately devolves into what is described as a guesswork or intuition. And he stated that that's particularly problematic because violating these federal laws can result in serious criminal prosecution and punishments. So Judge O'Connor concluded that this rule fails to provide adequate notice of what conduct is prohibited, and it is therefore vague and void for vagueness under the Fifth Amendment's Due Process Clause. But there was another portion of this ruling which involved the Second Amendment. The Second Amendment ruling may be even more important. SAF argued that Americans have a constitutional right to make and repair their own firearms, and the ATF's rule actually burdens that right by regulating access to the components necessary to do that process. And Judge O'Connor actually agreed in this ruling. The government apparently did not seriously dispute that making and repairing firearms falls within the conduct that is protected by the Second Amendment. That means that under Bruin, the burden then shifted to the government to prove that they have historical analogs or historical tradition and support to still regulate these items in this way. But the government had to establish that, and Judge O'Connor found that the government did not meet that burden. Judge O'Connor did not merely conclude that the government lacked adequate historical analogs, he also found something else. He concluded that the actual historical tradition points to the opposite direction of what the ATF put in place with this rule. The opinion discussed America's long history of individuals manufacturing and repairing their own firearms. And Judge O'Connor points to firearms manufacturing during the colonial period, the Revolutionary War, and also the early Republic. And he concluded that there was no restrictions on manufacturing firearms for personal use in America during the 17th, 18th, and 19th centuries. According to the court, the ATF rule here that was put in place by the Biden administration doesn't just lack historical support, it also conflicts with historical tradition of Americans and people within the nation making their own firearms. And based on that, Judge O'Connor concluded that the challenge rule violates the Second Amendment. Now, here's where we need to be extremely careful with what happened in this ruling, and we have some caveats with what just happened. This is not a nationwide injunction protecting every American. Judge O'Connor declared that the challenge portions of the federal rule are unconstitutional under the Second Amendment and void for vagueness under the Fifth Amendment and cannot be enforced against the plaintiffs themselves, like Second Amendment Foundation, their current or future members, and also the one company that is included in this lawsuit. But on top of that, the actual permanent injunction is specifically tied to just one product in this lawsuit. So don't interpret this ruling as meaning every unfinished frame or receiver in America is suddenly completely outside federal regulation. The scope of this injunction still very much matters, and it is very limited. There is also a caveat for what may happen next. This potentially sets up another extremely important appellate court fight. If the government here decides to appeal to the Fifth Circuit, essentially what could now happen is they could ask for the Fifth Circuit to address the express constitutional question like whether this rule violated the Second Amendment. And depending on what happens there, this case could conceivably find its way all the way back to the Supreme Court for the second time, presenting instead of a statutory question to the Supreme Court, but it would actually be a constitutional question of whether this rule actually violates something like the Second Amendment. Now, the next big question is how will the ATF and DOJ respond? Will they seek an immediate type of administrative stay on this ruling and also then appeal this case up to the Fifth Circuit? That is something that we're now going to have to watch for, and we don't have an answer to yet about how the DOJ will respond. So here's where things stand right now with this ruling. Judge O'Connor ruled that the challenge portions of the ATF's rule violate the Second Amendment and are also unconstitutionally vague under the Fifth Amendment. And he has permanently blocked enforcement against these plaintiffs, Second Amendment Foundation, their members, current and future, within the scope of this injunction, like I mentioned, specifically to this one product. This was a limited ruling that may also still be appealed up to the Fifth Circuit, so we will have to wait to see how the DOJ actually responds in this case, but regardless, this is another big ruling against the federal government and federal gun control coming out, and this is also just coming out of the Northern District of Texas, so now we have two big wins in just the last couple of weeks. Last week we had that NFA ruling also coming out of this Northern District of Texas federal court, and now we have a new ruling against the Biden era 80%er rule, restricting 80%ers and these types of part kits. So again, huge win, but we're going to have to wait to see how this plays out, similar to how the NFA ruling played out as well. So as we get more information, as we get additional guidance, and we see what the DOJ does in response, I will let you guys know. But if you want to stay up to date on what is going on in this case and other cases, make sure to subscribe to the channel and turn on all notifications to not miss these updates when I release them. But as always, thank you so much for all of your support. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.